Good morning. Court is now in session. Calling case number 251. Is Tyler James Robinson. Counsel, could you please enter your appearances?
Ed Grunander, Ryan McBride, and Christopher Ballard for the state, Your Honor.
Good morning.
Good morning, Your Honor. Richard Novak, Stacy Visser, and Michael Burt for Mr. Robinson. I believe Ms. Nestor is on an airplane somewhere, so she's not with us today. And Mr. Robinson should be appearing audio only from the jail.
All right. Mr. Robinson, are you with us? Thank you. Good morning to you all. The court now issues its rulings on the two outstanding matters that we recently heard. I'll start with the ruling in order addressing the defendant's motion for order to show cause. Defendant Tyler Robinson filed a motion for an order to show cause, docket 504, seeking an order requiring Utah County Attorney Jeff S. Gray and Deputy Utah County Attorney Chris Ballard to appear in court and show cause why they should not be held in contempt for violating the pretrial and trial publicity order originally issued on September 16th, 2025, and amended on December 15th, 2025. And as I'm reading this, I'm going to be filing my written rulings, and so I'm going to omit the citations to the dockets in case, but that will be in its full form. The motion is fully briefed. The court heard oral arguments on May 19th, 2026. Having considered the papers and the oral arguments, the court now rules and orders as follows. Defendant alleges the conduct occurred outside the immediate view and presence of the court. Thus, Section 78B-6-302 sub 2 requires defendant to file an affidavit or statement detailing the facts constituting the contempt, which statement, together with the subsequent court order, forms the basis of the contempt charge. Defendant's April 16th, 2026 declaration of counsel in support of the order to show cause satisfies that requirement. In the declaration, defense counsel identifies the alleged conduct and provides specific examples. Defense counsel asserts that Utah County Attorney Jeff S. Gray and Deputy County Attorney Chris Ballard violated the court's pretrial publicity order by making specific statements to various news outlets, including TMZ, USA Today, Fox News, Political Facts, and others. Accordingly, the court grants defendant's motion for order to show cause. The issuance of this order reflects a determination that defendant has made a sufficient preliminary showing under Utah law to warrant further proceedings and does not constitute a finding of contempt. An evidentiary hearing will take place during a 2026 proceeding. The purpose of the hearing is to determine whether the evidence establishes the elements of contempt, namely whether the Utah County Attorney's Office and its representatives knew what was required under the court's pretrial publicity order. The respondents had the ability to comply with that order, and the respondents, by making specific statements to various media outlets, intentionally failed or refused to comply with the pretrial publicity order. Because defendant seeks an order for civil rather than criminal contempt, and because the focus of the claims is on the potential impact the disseminated statements may have had on the potential jury pool, the court respectfully declines to issue an order compelling the Utah County Attorney's Office to produce the requested discovery. Each side will have 1 hour and 30 minutes to present evidence, after which the court will take the issue under advisement and issue a ruling at a future date. This is the order of the court. And that concludes the first ruling by this court. Turning to the second issue. This is regarding defendant's motion in limine to close portions of the preliminary hearing testimony and seal preliminary hearing exhibits. Defendant Tyler James Robinson seeks to close portions, if not all, of the preliminary hearing and to seal preliminary hearing exhibits. The motion has been fully briefed and oral arguments were heard on May 19th, 2026. At oral arguments, the parties agreed that neither the public nor the media should be permitted to inspect or copy exhibits presented at the preliminary hearing, except as published in court as part of the hearing. With the issue of the exhibits resolved, the court turns to the closure of the preliminary hearing itself. The public and the media enjoy a presumptive right to access court proceedings, including preliminary hearings. A party seeking to close a preliminary hearing must show that adverse publicity traceable to the open hearing poses a realistic likelihood of prejudice to a fair trial to overcome this presumption. The party seeking closure must also show there are no less restrictive alternative means to ensure the integrity and impartiality of the jury. Public access to judicial proceedings also serve in an important role in maintaining confidence in the fairness and transparency of the judicial process. This court finds these showings have not been made here. First, the motion does not identify with sufficient specificity that the evidence, if presented in a public proceeding, would create a realistic likelihood of prejudice to defendant's right to a fair trial. Despite receiving notice of the state's witnesses and exhibits for the preliminary hearing, the motion raises generalized concerns regarding hearsay and the expert reports without identifying particular evidence warranting closure. Furthermore, much of the evidence the state indicated it intends to offer during the preliminary hearing is already in the public arena and was identified in the information and probable cause statement. The possibility that evidence introduced at the preliminary hearing may later be ruled inadmissible at trial does not, standing alone, bar the public from the courtroom. The court, however, acknowledges defendant's pending motion in limine to preclude 1102 evidence and reserve ruling on that issue until the matter has been fully briefed and heard. Even assuming specific evidence has been identified that could present a risk to defendant's constitutional right to a fair trial, if publicly disclosed, the motion does not establish that a no less restrictive alternative remains available. Several methods remain available to protect the defendant's right to a fair trial, including enlarging the veneer of potential jurors, utilizing detailed juror questionnaires, and conducting thorough voir dire, all methods routinely used to safeguard a defendant's constitutional rights. For these reasons, the court respectfully denies defendant's motion. This is the order of the court. Counsel, I will go ahead and sign these orders and it will be uploaded to the docket today. And with that, I believe we have our next hearing on June 12th, starting at 9 a.m. And that is in person. I'm anticipating Mr. Robinson being present, and we will adjourn until that date.
Your Honor, may I just ask the court one scheduling question?
Absolutely, Mr. Novak.
So we have these two matters on June 12th. One is argument on the motion that the court just referenced, and one is the order to show cause hearing. Did the court have a preference for which of those two matters it does first and which it does second?
Let's go ahead and do the order to show cause first and the evidentiary hearing, and then we'll turn to the second matter. Thank you for that question.
Thank you. That's fine.
All right. Anything further from the parties?
Nothing from the state, Your Honor.
All right. Thank you to all parties. I wish you a good rest of your day. Court is in recess.
All righty. Well, that was quick. Interesting stuff. So he did give the defense their day in court about the potential violation of the dissemination order by the defense. But he did not grant their request for discovery. They wanted all of the communications that the prosecutor had with the media. That's quite an ask, to ask for internal communications on the part of the prosecutor's office. It's quite an ask. I'm not surprised he didn't give it. Mike, can you maybe go out of the room for a minute for me, please? And also, he denied the defense's motion for closure of some or all of the preliminary hearing. One of the things that he said is they didn't specifically say which parts needed to be closed, what stuff needed to be not shared publicly, and they didn't. It was very broad. I think this is part of prep for appeal more than they thought they would get this, because why didn't they give specifics? They really didn't give specifics. I don't know. Interesting. So that's what we know at this point, is that the preliminary starting on July 6th will be open. We'll see it all. It's scheduled for a week, and we will see everything that they're going to share. And they do get one hearing. They each get an hour to present on the violation of the non-dissemination order. They want some kind of a civil sanction, which would be money, I believe, if they find that the prosecution did do that, but the judge did not grant their request for discovery. So they do not get access to their internal communications. So interesting stuff. Things keep grinding forward. I think we're really going to have a preliminary hearing on July 6th too. So that's only a month away. It's about time. This has been dragging on for quite a while now. So we shall see. There is another hearing coming up in 2 weeks for Tyler Robinson. And it is it's like a motion to eliminate kind of hearing where they're going to discuss evidence that is in and evidence that's out. So the defense has ordered a bunch of stuff, a bunch of evidence that they want kicked out, basically. The judge is trying to get to as many of those things before the preliminary hearing, because one of the fears is that there'll be evidence in the preliminary hearing that will later be ruled inadmissible, and that could be problematic for the jury pool. So he is trying to get to those with the defense as much as he can before the preliminary hearing. But I mean, chances are very good that will happen. It does happen pretty regularly in these kinds of things. But I mean, the bottom line is they have to do voir dire, and they're going to find a jury, because not everybody follows crime like we do. You might think we do, but not everybody does. So there will be people, even in Utah County, who don't actually know about this case. And so we just have to let the process do its thing. We have to trust the jury selection process and the jury process. That's really all we've got at this point. So no special treatment for Tyler Robinson. Wasn't surprised. Really expected that this is exactly what he was going to say, because he'd already ruled that cameras can be present during the trial. And specifically the trial and the preliminary hearing were mentioned in that hearing as being particularly protected when it comes to the public's right to know. So there we are. Also, interestingly, and pretty much not surprisingly, the defense has filed a request for the Utah Supreme Court to review Judge Graf's ruling about having cameras in the courtroom. So they're still fighting to get cameras out of the courtroom. They're saying that because of the heavy publicity of this case, that he can't get a fair trial. You know the spiel. We've heard it tons over the last few years as trial streaming has become more the norm. We'll see. If I kind of doubt they're going to overturn the judge. That it would take overturning his ruling, and I really doubt that's actually going to happen. But they're seeking every recompense they can, because that's their job. and then they can use that also in appeals. But I think we're going to get exactly the same answer that we got today and then we got in the last ruling about cameras. They're in, quite sure of that. So, all righty. Well, I'll be back over on our main channel, True Crime Squad, at 6 p.m. Mountain tonight with Katie for a full episode. Thanks for joining us today. We've got a couple other things coming up. Brendan Banfield is going to finally get sentenced on Friday this week, the 5th. And there will be some Stacey Wondra update tomorrow or the next day. There's a hearing tomorrow. They only post them after the fact. As you know, it's very frustrating. So I will do an update with you as soon as I know what's happening with that. And of course, we'll be streaming Banfield on Friday. So thanks for joining me. You know it. This has been True Crime Squad Trials.